Hi everyone, and thank you for joining us for today's Use Laboris client webinar to discuss how the COVID crisis is being handled by companies in Eurasia. My name is Annie and I will be facilitating this webinar for you today. So today's presentation will be given by a set of panelists who are all lawyers in the Use Laboris firms in Russia, Belarus, Ukraine and Kazakhstan. So that is it from me. I will now hand over to our first speaker, Irina Anyukhina from Russia. Go ahead, Irina, you can start.
Thank you, Annie. Hello, everyone, and we are very glad that you are able to join our webinar. Let me present our speakers first. My name is Irina Anyukhina. I'm from Russia. I'm head of labor and employment team at Al-Rud law firm based in Moscow. My panel of speakers also comprise Daria Zhuk, managing partner of Cobalt, Use Laboris Belarus, Valeria Savchuk, leading on labor and employment issues at Vasil Kyzel and Partners from Ukraine. Vasil Kyzel Partners is Use Laboris Ukraine. Larisa Yemelyanova from Equitas, Kazakhstan, Use Laboris Kazakhstan. And we are glad to discuss today and share with you our key considerations with respect to different restructuring tools which are currently considered by the businesses because of the current uncertain period of COVID and post-COVID times. So quite a lot of businesses in our region, they are reviewing their market strategies because they faced quite a challenges on the market, and quite often businesses are considering restructuring headcount of their offices in our respective countries. Today we will discuss available means of restructuring in our jurisdictions, which are practically one and the same. But since on the national level different specifics exist, we decided to share with you for practical needs those key considerations so that you are well prepared if you are considering or are already implementing this or that tool. Let's move on to the first slide. I will start by describing generally the types of restructuring available in Russia, and then my speaker will add comments from their jurisdiction point of view. So the most common ways of restructuring in our region, you can see on the slide, are staff redundancy, transfer to another job or position, switching to downtime or distant work, other changes in the terms of employment, including reduced hours, reduced salaries, outsourcing and outstaffing approaches. Liquidation also stands as an option for small and middle-sized local offices which operations were largely affected. Of course, these types of restructuring differ in terms of purposes, timeline, guarantees to the employees. However, all of them are common in our region by the requirements to comply with national mandatory procedures. Such procedures in Russia, for example, are very formalistic, multi-stage, and in most of the cases require advance notification of the employee. And in case there is a trade union, also consultations or coordinations of the forthcoming changes with the trade union. I will not dwell about outsourcing and outstaffing because we will be covering this a little bit later on during our webinar in more detail. So let me first speak about staff redundancy, which is the mostly frequently considered options for the businesses for the restructuring. It is quite frequently used in Russia. Formally, there is no need to obtain consent of the employees for the redundancy. So this is good news, but there are some crucial important things to keep in mind because they are mandatory. First, in Russia, there are protected categories of employees. They are protected against redundancy. Pregnant women, sole breadwinners, those who have minor children, some others. Second, if there are several employees holding one and the same position, the employer should do a thorough formal selection of the employees who will be selected for the redundancy. Such selection should be done based on job criteria, performance assessment. The selection stage is very, very important, since the employer should have sufficient evidence to justify the selection of the particular candidate for the redundancy in order to avoid any claims. Further, it is mandatory in Russia to offer vacant positions to the employees who are made redundant. And redundancy in Russia implies 2 or 3, depending on the circumstances, prior notice to the employees and payment of severance, minimum of 1 average salary. The maximum severance payable to the employees is 3 average salaries. Liquidation implies nearly the same procedure of terminating the people based on the decision to liquidate the Russian office. Severance of 3 average salaries should be paid to the employees of the liquidated company. And it's quite important that launch of all terminations is possible only if the shareholders approved decision and formalized decision on liquidation. The current experience of COVID time shows that the top popular ways of restructuring were mainly led by transfer of people to remote work and reduction of working time. Remote work arrangements should be formalized in Russia. This is a specific type of employment arrangement and should be formalized appropriately. Change of working time, change of working regime, reducing working hours is subject to employees' consent and requires also formalization, since these kind of changes affect the core employment conditions, place of work, and working regime. Curiously, currently in Russia, combined work, possibility to work both from distantly and from the office, is not possible. It is not regulated by law, so it's not possible to do a mixed form. It's not possible to put it in one and the same employment agreement. But good news is that the parliament is currently considering draft law to change that approach. In Russia, there are cases when employers may unilaterally set partially paid downtime regime and change essential terms of work. This allows to save, of course, costs, because in case of introducing downtime regime, for example, due to external reasons like pandemic, for example, or lockdown, the employer could switch employees to downtime work and pay them at least 2/3 of their monthly or base salary. So it's not possible to switch to downtime without payment any fees to the employees. If we then move on, so also the businesses, our clients in Russia, they also often use the approach when they transfer the employees to other work. So this may be done by unilateral decision of the company, by the decision of the employer, only in a very specific case. So this may be done for a period up to 1 month when downtime is caused by economic, technological, technical, or organizational reasons. And in case of pandemic or natural or industrial disaster. So in case of such transfer for short time period to 1 month to such other job positions, still the employer have to pay not less than the average earnings of the employee in his or her initial job. And it's not possible to transfer to the job requiring lower qualification unless the employee consents to it. Now I will resume in Russian and ask my colleagues to highlight their key considerations from their respective jurisdictions. Let's move on to Ukraine. Valeria.
Yeah, thank you. Okay, in Ukraine, when the pandemic, COVID pandemic started, the most popular way to deal with circumstances was to put a downtime for employees, and this was like a first response of the business to the COVID pandemic. I would say that the types of restructuring in Russia and in Ukraine are very similar. Of course, we also have, in case of redundancy, we also have an obligation to consult trade unions, to notify employees 2 months prior to redundancy. Of course, we also have an obligation to propose all vacant positions, and there are also some employees who may not be dismissed due to redundancy. And the categories of employees are also the same: pregnant women, single mothers, sole breadwinners, and so on. But now the most common way to deal with the COVID pandemic is remote working. I would like to say that before April this year, we did not have any regulation regarding remote working. And in April, we had a new law. And according to the law, we now can put employees on remote working, and also the good news is that during the quarantine, employers may put employees to remote working unilaterally without any changes to the employment agreements. And now also our parliament considers a new draft law which will regulate remote working a little bit better, because the first attempt to regulate the remote working was not so successful. There was some additional questions which arose from the first law on remote working, for example, regarding health and safety during the remote working. Who is responsible for all these injuries which may happen to employees who are on remote working regime, and so on. And now we have a new draft law which is more complex and gives some additional answers to all these questions, and we expect it to be effective by the end of this month or by the beginning of next month. I would say that transfer to another work is not so popular in Ukraine, another job or another position, because first of all, the process is very bureaucratic, and secondly, the transfer should be done by the confirmation of the employee. If in case the employee does not give their consent to such transfer, the transfer may not happen, so it's not so popular in Ukraine. So I will pass the stage to Belarus. Daria.
Thank you, Evgenia. Thank you, Irina, for very comprehensive analysis of workforce restructuring options. I would say that per Belarusian law and market practice, the listed options are also quite workable solutions. But in Belarus, we are following here, I mean, in terms of COVID pandemic issues, we are following here like Swedish model, and we did not have and are not planning to have official lockdown or quarantine. That's why like most like options that were selected by business is surely either remote work or part-time work, or for instance social leave without compensation. I would also notice at the general remark that in Belarus we have quite employee-friendly and quite strictly regulated employment legislation and market practice, and all these options shall also be very good documented and formalized. For instance, if you would like to apply staff redundancy or part-time option, we need to justify these decisions by economic, financial, production reasons, and these reasons shall be communicated to the employees in written. For instance, we still require like wet signatures, even if we exchange documents in PDF format. The original counterparts exchange is also required at the moment. I would say that in Belarus, unlike in for instance in Ukraine, as we've heard from Evgenia, the remote work is quite good regulated since the beginning of this year. We have amendments into our labor code, and the remote work shall be either formalized by additional agreement to the contract, if we speak about this remote work during the employment terms, or it could be launched at the change in essential work conditions that also require advanced notifications of the employees. What was changed due to COVID-related issues is that minimum notice period for changes to essential work conditions is now shortened to 1 business day. Normally it was 1 month. But if we speak about reduction in remuneration, then we still need 1 month's written notice. And as a final remark from my side, I would say that most of these options of restructuring require employees' consent. Without employees' consent, we may have staff redundancy, downtime or liquidation, and suspension from work. The rest of the options still require notification and consent. So I would gladly pass the floor to Larisa, to Kazakhstan, for their remarks.
For Kazakhstan, I have 5 comments. First, staff redundancy procedure in Kazakhstan is quite easier than in other countries. There is no need to propose vacant positions to the employees. However, we do have some protected categories for staff redundancy. Second, if a company is to be liquidated, there are no protected categories of employees. However, this basis can be used only when a legal entity is to be liquidated. It cannot be used for liquidation of a branch or representative office. Third, an employer has right to transfer an employee to another job without consent of this particular employee. However, normally it can be done up to 3 months per year. However, in case of downtime of this employee, there is no limitation of period of time to such transfer. Fourth comment. Changes to working regime are possible. However, in most cases, they require employees' consent and amendment to the employment contract. We do have some flexible possibility. However, there are some legal requirements to introduce them. The only possibility to change a working regime without employees' consent is downtime. Downtime is a paid option. Even the salary payment is reduced to the employee, but this is not a free of charge option.
And finally, we do not have a free of charge option which can be introduced by the employer without employee consent. The only possibility to do this is a situation when employee by himself requests the unpaid leave. That's all for Kazakhstan, and I pass on the floor to Valeria Ukraine, who will be talking on the next slide about restructuring wage fund. Thank you.
Yeah, thank you, Larissa. Another way to deal with COVID pandemic in Ukraine is to restruct in some way wage funds in the company. And here on the slide, you can see the most common categories of payments to the employees, which may be alternated by the employer. But firstly, I would say that three things should be kept in mind in this case. First of all, to change, increase or decrease payments to employees, the employer should have a business reason, a solid business reason, which should be documented in the separate document named technical economic grounding or reasoning. And in this document, the employer should describe all reasons why the payments to employees should be decreased or postponed in some way, because it's like it should be considered like an amendment to the employment agreement, but this amendment is done by the employer unilaterally without any consent of the employee. Another thing is that the prior notification to the employee should be, the employee should receive a prior notification 2 months prior to any changes in case of decrease of salary or bonus or any other additional payments. And the third thing is that there are some minimum state guarantees guaranteed by the state, and for example, the minimum salary in Ukraine, the minimum monthly salary in Ukraine is 150 euros per month, and there are also categories of employees, namely foreign employees employed in Ukraine, who should receive a higher salary. For example, for foreign employees, regular foreign employees employed in Ukraine, the minimum salary is 1,500 euros, and for highly qualified foreign specialists, the amount is much higher, is 7,500 euros per month. So these are a minimum guarantees guaranteed by the state. Also, there are some severance payment which are guaranteed by the law. For example, in case of staff reduction, the minimum severance payment is one average monthly salary. In case of dismissal of the top management, the severance payment is 6 monthly salaries. Of course, there are no requirements to the severance payment in case of mutual termination agreement. Usually, the severance payment in case of not forced dismissal, I mean that the mutual termination agreement is concluded between the employer and employee. The severance payment varies between 3 and 6 monthly salaries. In case of top management, between 6 and 12 monthly salaries. Sick pays are paid by the state. Only first 5 days of sick leave are paid by the employer. The rest of days are paid by the state from the special state fund. And the last thing I would talk here on this slide is the delays in payroll, because the fines in this case are considerably high. For example, in case of delays in paying salary, the fine is 450 euros per one employee, and in case the salary is not paid to the foreign specialist hired or employed in Ukraine, the state may revoke the work permit for such foreign employee. Okay, that's it for Ukraine. I would pass the word to Daria from Belarus.
Thank you, Valeria. I would also generally comment that the approach is quite similar in Belarus too, to this restructuring wage fund options. In case of employment termination, the employer should consider payment of salary, compensation for unused labor leave, and severance payments. For example, in case of liquidation, in the amount of 3 average monthly earnings. In case of termination or refusal to work under the changed or essential working conditions, like for instance, reduced salary or working hours, then employee is entitled to receive 2-week average earnings. Sick pays also compensated from the Social Security Fund, but here the approach is a bit different. For first 12 calendar days, the employee got 80% of the average daily earning, and afterwards 100% for each next days for temporary disability. Delays in payroll also may cause some administrative fines, but they're not so high. But the risks here are that delays may be considered as reasonable grounds for termination of the employment at the employee's initiative. And then such termination will be subject to severance payment depending on the provisions of the employment contract, but it may be from 2 weeks to 3 months average earnings. And also delays in payroll may cause the inspections from state labor inspection, and which also can trigger some other facts of misconduct from employer side. So that's why delays in payroll are not very recommended here in Belarus, and surely the employer should try to seek some other options like part-time or reduced working hours, something like that. So I think it's all from my side, and I'd like to pass the floor for comment to Larissa, Kazakhstan.
Mm-hmm. I have also 5 short comments for Kazakhstan. First, bonus schemes and additional payments can be changed unilaterally by the employer only if they are not a part of a labor contract or a collective bargaining agreement. Second, severance pay in case of forced redundancy or liquidation of a company is equal to 1 average monthly salary. However, the employer must notify the employee and the state inspection about future dismissal at least 1 month prior. So an employee will give from the employer approximately 2 salaries or more, and then he will be entitled to get some more compensation from the Social Security State Fund. Third, minimum wage in Kazakhstan is approximately $100, which is less than in Ukraine. However, we do not have specific guarantees for higher qualified foreign specialists. Fourth, Sick pay is paid in Kazakhstan by the employer and is limited by approximately or even less $100 US. This limit is not applicable to the professional disease or to injury at workplace. This is important because COVID illness can be treated as professional disease if the company fails to follow all sanitary measures. And the final comment, we do not recommend delays in payroll in Kazakhstan because they can lead to an administrative liability of the company, which is approximately $1,000 per each violation. Also, there is a crime article in our crime code, however, it is not frequently used, and then the company will be obliged to pay penalty for employees per each day of delays of salary. So that's all for me, and Irina, please comment what is happening in Russia.
Yes, in Russia, I'd like to be as fast as possible because we are running a little bit of time. So base salaries in Russia may be changed only if the employee agrees. So normally, if the company has a variable part of the salary or bonus schemes, the companies prefer to switch to changes to that parts of the remunerations. Discretionary bonus, it's up to the employer to decide whether to pay or not, because this is at the discretion of the employer and this is fair and legal. But if the employment agreement provides for guarantees to the employees, guarantees to pay the particular bonuses, so these bonuses may not be deferred. The practice currently is that these discretional bonuses are deferred. As regards additional payments, they are practically suspended because here we mean that in Russia, for example, it was quite a practice to compensate expenses for the meals, expenses for the car, things like that. This kind of payments are normally suspended. So same as in other countries, it's not possible to go beyond the minimum wage. It is a good thing in Russia when an employee is absent from work due to health reasons. It is beneficial for the companies to pay sick allowances, because this is also from the state fund, as in Ukraine. Because sometimes companies are considering to put the employee on the paid leave. This is not equivalent from financial point of view. And one additional important point, indexation. Indexation of salary in Russia may not be abolished. So even if there are decreases in the wage fund, indexation still applies. This is sort of increasing the salary, even if the promotions are frozen. Increases to cover the inflation rate should still be conducted by the companies. Let's move on then to next topic we would like to discuss. That's about outsourcing, and let's start with Belarus.
Yeah, thank you, Irina. So I would also be very short, try to be very short, because outsourcing, it's not a new option. I believe it is true for all our 4 regions. It is quite workable solution, quite recognized as per our practice, for instance, market practice. And surely to restructure the workforce and reduce labor costs, employers may apply to outsourcing model, and usually it is used for non-production functions like IT support, accounting, legal, financial services, and some others. Outsourcing is possible when the following conditions are fulfilled. Employees of the service provider are not supplied to another party. So they perform the services under the agreement on behalf of the service provider company. Subject matter of such agreement that is concluded between two companies is rendering specific services or works. Service providers shall exercise all managing decisions and powers of the employer. The other party, the client, may assign tasks to the service provider's employees and even may assess their performance. And then, for instance, to accept or not to accept the act of rendered services that would be supplied at the end of the period of this agreement. Outsourcing agreements do not affect the terms of the employment of personnel of each of the party to the such service agreements, and no transfer of employees or as well as any other employment related changes, they do not take place. So each party, they maintain employment relations with its employees on their own. So this is general comment from Belarusian perspective, and I'd like to invite my colleagues to comment. So Kazakhstan, I think Larissa. So yes, please.
Yes. Outsourcing of functions in Kazakhstan is frequently used. However, we cannot use outsourcing for replace executive or other managing bodies of a company. Of course, a written contract is required. Please include in these outsourcing contract specific services to be done by a service provider, not an employee, which is subject of outstaffing, about which we will be talking a bit later. So specific services is to be included into the contract. Even if an employee of a service provider is going to the premises of a host company to fulfill such outsourcing contract, this employee cannot be treated as an employee of a host company. However, the host company in some cases can be made liable for injury of such also outsourced person. Therefore, we would suggest to companies have in place regulations about safety for external visitors, and then including into the outsourcing contract obligation of service provider to ensure all safety measures for its employees. That's all for me. And Irina.
In Russia, there are no restrictions to outsource. Nearly all functions may be outsourced, so even the position of general manager may be outsourced to a management company. These are mainly civil law relationship rather than employment, so no employment law applied to outsourcing in this case. Some specifics exist when there is outsourcing of, for example, chief accountant function position. So chief accountants in Russia have special liabilities, and due to Russian taxation and accounting laws, in case the function of chief accountant is outsourced, it is most likely that the liabilities for the service provider operations on the corporate level should be undertaken by the general manager. So formally, the same way as in other countries, outsourcing does not imply any employment-related relationship between the service provider personnel and the people of the customer. So it's quite a widespread practice in Russia for IT, legal, and accounting operations. That's it for Russia, and now let's fly over to Ukraine.
Yes, thank you, Irina. For Ukraine, the comment will be very short because we do not have any specific regulations regarding outsourcing. We have some specific regulations regarding outstaffing, but it will be on the next slide. The outsourcing usually works based on the civil civil agreement, services agreement between the two companies, and not only accounting functions or IT functions may be outsourced. Many other functions can be outsourced based on this service agreements. Even in some manufacturing, I know our client outsourced some other functions, production functions, for example, or packing functions, and so on. There are no specific regulations with regard to taxation. Of course, in case what Irina said, in case the chief accountant position is outsourced, the general manager or general director will be liable for any breaches of tax law and so on. So I think it's all for Ukraine. Thank you. We can move to outstaffing slide about outstaffing, and Larissa will present it.
Outstaffing is a type of service contracts. However, the subject of outstaffing is quite different from outsourcing contracts. The subject of outsourcing is a specific product, I mean eventual result of a service or a work. And subject of outstaffing is a person as a manpower or production asset. In this meaning, outstaffing in Kazakhstan is only possible for intra-group of provision of personnel. There are three types of possible outstaffing in Kazakhstan. Secondment, which cannot be used for foreign employees for whom it is required to get work permit. So secondment is possible to use only for local employees, and is in some cases for employees from Russia, Belarus, and some other countries to whom is not necessary to get work permit. In this period of time, secondment is not workable because of limits to this procedure. In particular, it's not possible to use secondment in order to replace some employees who put on downtime in the host company. Intra-corporate transfer of foreign workers and temporary transfer of foreign workers are used for employees from the abroad under the work permit regime. Unfortunately, it is quite difficult to bring employees now from abroad to Kazakhstan because of close of our borders. It's necessary to obtain a specific permit from governmental committee in order to allow foreign employees to come to Kazakhstan. This is not a work permit, this is additional anti-COVID permit. There are many questions whether possible to use out-of-group outstaffing of personnel. Unfortunately, this type of services, outstaffing services, is still in gray area in Kazakhstan legislation. Outstaffing of personnel by recruitment agencies is not allowed specifically. However, it exists, and our parliament consider a new law by which outstaffing services of recruitment agencies can be legalized soon. But the law considers some limitations for outstaffing of personnel. So unfortunately, in not in all cases it can be used. Finally, we would not recommend use outstaffing schemes in Kazakhstan and replace them by outsourcing. Thank you for your attention, and Irina, please comment to Russian.
In Russia, I think the situation is totally different. In Russia, it is possible to use outstaffing as a solution. Outstaffing services may only be provided by the private agency who have undergone special registration, accreditation, meaning they are sort of, if you wish, licensed to render this kind of services. There are no regulation yet with respect to intra-group exchange of personnel, like secondments or transfers of foreign workers. So in Russia, there is a ban on lease of work, but it is possible to use agency workers under certain specific conditions. For example, it is not possible to substitute by the agency workers of the employees who are on strike or who decided not to work because they do not receive in time payment of their salary. Or if, for example, the employer obtained a license or a certificate because he has in his headcount qualified specialists for this. So in such case, the employer is not able to substitute by agency workers these qualified specialists. It is possible to use agency workers for a period not more than 9 months, and it is possible to use not more than 10% of the headcount to use agency workers, not more for 10% of the headcount of the company. This is in a nutshell about Russia, and let's move on to Ukraine.
Yeah, thank you, Irina. We have special legislation regarding outstaffing, and outstaffing is broadly used by employers by companies in Ukraine. We do not have any regulations on intra-corporate transfers of employees, but the regulations we have are about recruitment agencies. There are 2 types of recruitment agencies in Ukraine. First group are the agencies who employ workers to send them to the Ukrainian companies, and the second one employs workers to send them to some foreign companies. You may know that in Ukraine, working abroad in Poland, in Germany, in France is very popular now in these days. Even in COVID-19 times, our Ukrainian citizens are going to Europe to work there. So this type of recruitment agencies is very popular. We do not have any restrictions regarding the time or the period of time when for which the agency may send the workers. It may be for several months or several years even. The only restriction is that the company who undergone some reduction of staff may not engage these employees of the agency to substitute the reduced positions, and also in case the company who wants to engage some employees of the agency has the trade union, the company should obtain consent of the trade union to do so. So these are only limitations in Ukraine. So Daria, anything for Belarus?
Yeah, thank you. Well, in Belarus, we're very close to Kazakhstan approach. It is not, outstaffing is not regulated, and I would even say that it's not explicitly recognized and recommended, because it could be called void as an option, as a model, and there is a risk of co-employment, for instance. So that's why in most of the cases companies use outsourcing model for such kind of ideas of restructuring. We do have our staffing license for foreign employers, and we have agencies on the market that do have this license, and they outstaff Belarusians to foreign employers, but it's not recognized, and it's not well developed and established for local or intragroup companies. So I think this is all from my side, and I guess we may switch on to the questions.
Yeah, I see that we do have questions. They are very detailed and very specific. So some of the questions are already, there are some arrangements with the speakers that they will be discussed after the webinar. In the meanwhile, we still have a couple of minutes for some clarification. So the question, for example, to Belarus, is it possible to use outsourcing model with foreign clients, employers?
With foreign clients, it's possible, surely. But as I said, you may also try to use this outstaffing model, but apply to professional and licensed outstaff agency. With foreign clients, yeah, it would be like business to business, civil contract arrangements and agreements. But there are also like outstaffing agencies who may professionally help with that.
Thank you.
Thank you.
I also have a question to Ukraine. Is it possible, this is quite an interesting question, because for Russia this is very much similar. Is it possible to force employees to take unpaid vacation days during the COVID pandemic?
No. It's not possible, unfortunately. And this was the first response of our parliament to the COVID-19 pandemic. They said okay, in a few days after the quarantine was announced, and they said in a few days we will have a solution for all employers, and you could force employees and so on and so forth. But after the amendments were done to the labor code, we saw that yes, of course, the employer may give employees this unpaid leave for the whole period of quarantine. And for now we have quarantine starting from mid-March, and the quarantine will run till end of October. So the employer theoretically may give employees this unpaid vacation for all this time, but only if the employee asks for this unpaid vacation. So solution really is not a solution.
Thank you, Valeria. Question to Kazakhstan. A company has laid off some employees a month ago under the staff reduction procedure. However, situation improves and we would like to hire new specialists to the same position. Can we employ them? Larissa.
We would not recommend to employ them in such a short period of time, because there is a high risk that the staff redundancy will be recognized as fictitious. So let's wait until the limitation period is expired, which is 3 months in general. But we would recommend wait until 1 year, after which in practice the risk will be minimized.
Thank you, Larissa. 1 year is quite an essential period of time. So in similar situations in Russia, for example, we normally say, well, first, it is not possible to rehire immediately. For risk avoidance, we normally recommend to wait at least half year, 6 months, just not to be exposed to risks on fake redundancy. Thank you, Larissa. And there is also a question to Russia. Are there any restrictions to hire individuals as independent contractors by a Russia-based company? And formally, there are no restrictions indeed. So it's possible to hire independent contractors instead of employing them. But it will be an issue, a big legal issue, if, for example, you terminate your employees and rehire them as independent contractors, because this will most likely lead to the risks of claims that this is hidden employment with all respective consequences, both on the side of the employees as well as on the side of the state authorities, who may penalize the company for this kind of arrangements. But if these are the newly hired and there is a reasonable economic situation to justify that the independent contractor is really an independent contractor without who doesn't follow the corporate HR policies, who is free and acts, doesn't ask for vacation time and doesn't ask for the vacations to be paid. So this is reasonable and possible in Russia. I think we have a couple of more minutes because I have one more question, if possible, for Ukraine. It's interesting, is an employer responsible for fulfillment of occupational health and safety rules of remote workers?
As I said earlier, we had the first attempt to regulate the remote working, and unfortunately, the first attempt did not give the answer to this question. And generally, as a general rules, the employer is responsible even for those injuries which happen to remote working employees too. But according to the draft law, which is now considered by the parliament, the remote workers are responsible for the health and safety rules at their at home or at any other place they choose to work. But still, it's only a draft law. According to the current law, the employer is still responsible for any injuries which may happen to the employee.
Thank you, Valeria. And if I can, just one additional question to Belarus. What are the requirements for outstaffing of Belarusian employees abroad?
Thank you, Irina. Yeah, as I said, such agency would require a license, and the licensing requirements are quite simple. For instance, in the staff, in the list of the staff of such company should be the specialists with the prior experience in tourism or HR search services. And the company shall have a partner agreement with some foreign employer where it plans to outstaff the Belarusians. And then the Ministry of Internal Affairs inspect the company, and well, usually the license is granted. So it's not difficult to get this license now. The only is qualification of the personnel who is going to work in this staff agency, and then some partner relations with foreign companies.
Thank you, Daria. One more question, if we still have time, Ani, or we do not. If we do have time, I have a very good question for Kazakhstan.
Yeah, go ahead and take the question. That's okay.
Yeah, it's very interesting. It is a very interesting question. Can we switch employees between full-time, part-time, and remote work without making changes to labor contract?
Yes, this is a hot question for this period of time. In our opinion, it's impossible to put employees to part-time work or to distance work by the employer's decision, for example, by an order of the employer. These types of work requires employees' consent and amendment to the labor contract. However, we suggest using a flexible scheme for remote work. For example, conclude amendment to the labor contract where it will be written the basic terms of remote work, and then give the employer right in this amendment to the labor contract to introduce remote work and then take employees back to office by an employment order. So in the beginning will be agreement with the employee about terms and conditions for such switching on between different regimes. This will be, we think, a good solution for the employers. This could be also partially introduced with regard to time. However, we cannot introduce part-time without employees' consent. But what we do for our employees in our company, we introduce into the employment agreement provision when the employer can cancel part-time regime and give employees back to office for full-time regime by its order. This will be for benefit of employees. Therefore, we believe that it's really possible to make easier the life of the employers.
Thank you, Larissa. Other questions which were in the chat. So I think the speakers will get in touch with you directly just to discuss those questions since we have run out of time. And I pass the floor to Ani.
So that is it also from me. I would like to thank you for participating today and hope to see you or hear you next week. And thank you also for our panelists for their insights. So with that, this webinar will now be ending. Thank you all.